Hello everyone, welcome back to today's video. In this episode, we are covering a right to travel trial involving a sovereign citizen case that I've been following closely for quite some time. I waited until everything was finished so I could present the full story clearly and in proper context. This case has several interesting moments, and it gives a good look at how these situations play out in court. If you're curious about how these arguments hold up legally, this video will walk you through it step by step in a simple and easy way.
The people of the city of Lansing versus Rambo L, file numbers 22L2761882, 881, and 883. Counsel appearance, please.
Matt Staples on behalf of the city of Lansing.
Okay, and then Rambo L is present. Do you have an attorney, sir?
I'm here by special appearance.
Okay. Mr. Staples, my understanding is that you're moving to dismiss these.
Just the failure to display ops, Your Honor. I did check the Secretary of State. His license is valid, and he did show me that license, and that he does have it in his possession, so that the misdemeanor charge would be dismissed.
Wait a moment. Did you just mention that he actually holds a valid driver's license? That detail changes the situation quite a bit. If he has willingly obtained a license, it suggests that he has already accepted the legal framework set by the state for operating a vehicle. This raises questions about the consistency of his position, especially if he is also claiming a separate right to travel without regulation. It becomes important to look closely at how these two ideas fit together in his argument.
I believe
Okay.
Mr. L is planning on contesting those charges.
Is that correct, Mr. L?
Yes.
Okay, we'll set them for a hearing. February 14th at 9:30. Any additional matters for the record, counsel?
Nothing for the city, Your Honor.
Okay, you're all set, Mr. L. We'll see you on February 14th. Okay, is this L Rambo or Rambo L? You're muted. You have an attorney, sir?
No, I'm here by special appearance.
Okay, I'll put you in the private meeting room with the city attorney.
Your Honor, we've actually already met with Mr. Rambo L before. He was requesting a formal hearing on these two files.
Okay, sounds good. Formal hearings will be set for in-person appearance.
Actually, I filed a motion January 6th. Is when it went unanswered. I would like the court to dismiss this matter.
The effort was clearly unsuccessful, though it was interesting to observe how confidently he asked the court to dismiss the case without presenting any solid legal basis. His approach seemed more based on personal belief than on established law, which made it unlikely to succeed. Even so, it highlighted how individuals sometimes misunderstand legal procedures and expect outcomes without proper support. In the end, the court remained focused on facts and legal standards, showing that decisions rely on clear reasoning rather than unsupported claims.
Motion for challenge of jurisdiction that I submitted to the clerk, and I've served everybody, all parties. How long does he have? Because that happened January 6th.
I see it's a motion to show authority.
And also a demand for dismissal, lack of jurisdiction, failure to introduce evidence of an injury in fact, challenges jurisdiction of the court to prosecute. That was filed January 6th.
We only have one motion attached to the file. I don't see the other motions that you're referencing, sir.
It's timestamped by the court. I have it right here.
I see a motion to show authority, which the court has denied. And then there was a memo that was attached. There was not any other motion.
From a legal standpoint, there is an important distinction to understand here. The document presented appears to be a notice rather than a motion. A notice simply informs the court and all parties about an intention. In this case, the intent to seek dismissal based on certain reasons. However, a motion to dismiss is a formal request that asks the court to take action and requires proper legal support. Without filing that motion, no real step has been taken, and it suggests a misunderstanding of how court procedures work.
Not a motion. A notice is exactly what it sounds like, a declaration to all parties of the trial. And in this case, it's a notice of your intention to demand a dismissal of your case based on the reasons listed on the paper. Now, where's your motion to dismiss? Because without that, you've done nothing but put the entire courtroom on notice that you have no idea what you're doing.
It's filed with the clerk. Everybody was served.
Mr. Staples, did you get a copy of the motion he's referencing?
I see a copy of the motion to show authority in our file. I don't recognize it as any sort of valid motion or pleadings, but I see a copy of it in our file.
Agreed. That's the same the court has. It's a motion to show authority. The other motions that he's referencing was not properly filed with this court or served as the court. Neither the court nor Mr. Staples' office is in receipt of it. The motion to show authority was denied. Is not in proportion with the Michigan court rules. It does cite, however, Luke 11:46, the King James version, Luke 11:52, as well as some other.
It appears that the individual has chosen to rely more on personal or religious interpretations rather than following the established court rules in Michigan during these proceedings. While personal beliefs can be meaningful, legal cases are decided based on formal laws and procedures that courts are required to follow. Setting aside those rules in favor of another framework creates confusion and weakens the argument. This situation highlights the importance of understanding and working within the proper legal system to present a clear and effective case.
This is not a lawful or appropriately filed motion, and for that reason, it was denied before this court. But we will.
Well, I like to challenge jurisdiction right now. I have the right to travel.
An appropriate motion with the court under the Michigan court rules to challenge jurisdiction. But what we won't do is entertain motions under the King James version of the Bible. Okay?
That was a different motion you're referring to. That was the motion to show authority.
We don't have the other motion, sir. So you can file that motion. It's just we don't have it. I don't know why we only have one motion. That we don't have the other one you're referencing. So you'd have to file that and serve it on the city attorney. We'll give you time to do that. I'm going to set both of these matters for hearing, though.
I can't chill. You telling me I don't have the right to challenge jurisdiction right now? I want to challenge jurisdiction right now.
You can file a motion for challenging the jurisdiction, sir.
I can't do a verbal motion?
No, you cannot.
So you telling me I don't have the right to do a verbal motion?
You don't have a right to do that. You're going to file it in writing and you're going to serve it properly on the parties that you're filing it against. Okay, sir? March 14th at 10:30 in person at the court will be the date for the formal hearing, and then we'll hear any arguments on motions if necessary. You have any questions today, Mr. L?
We have now reached the third and final courtroom appearance in this case. At this stage, the individual continues to rely on personal interpretations influenced by religious ideas, rather than focusing on established legal procedures. This final segment brings together everything that has happened so far, offering a clear view of how the arguments have developed over time. It also sets the stage for the court's response, as the process moves toward a conclusion based on formal law and proper courtroom standards.
Thank you. Today's the date and time set for a formal hearing. I have, I believe, one witness on Zoom. Counsel, you can proceed.
Officer Vanderwerf, would you state your name for the records, please?
Oh, you want to call him? Let me.
Oh, I'm sorry.
Swear, man, no worries. Vanderwerf, can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, Judge.
To keep things clear and focused, I will not go through every detail of the prosecutor's questioning of the officer who conducted the traffic stop. Instead, I will highlight only the key points that are most relevant to understanding the situation. This approach helps avoid unnecessary repetition while still giving a complete picture of what matters in the case. By concentrating on the important parts, it becomes easier to follow the events and understand how they contribute to the overall outcome of the proceedings.
Southbound on King, when I observed a pickup truck in front of me that was changing lanes, failing to use its signal. So at that time, I activated my overhead lights on the vehicle to initiate a traffic stop. And then I made contact with the driver, who was later identified as a Rambo L. In our contact, he ended up handing me a piece of paper. At brief glance, when I looked at the piece of paper, it appeared to have what I believe was certain MCL codes that the subject may have typed onto the piece of paper. When I had asked him for a driver's license or identification, he was not really very cooperative. I also don't believe I was provided any insurance. At that time, I decided to issue him a citation for failing to signal, changing lanes, and failing to display a valid license, and then also the license plate through the system was expired.
Mr. L, did you want to question the witness?
Yes. The document that you were referring to, it was a travel document. I was showing you, I was traveling versus driving, and I tried to explain that to you. And then you held me on the side of the road for approximately an hour. I requested a supervisor because they might better understand what I was doing, and you never provided that for me. Is that correct?
That's actually incorrect, because the reason that you were held on the stop for as long as you were is because I was waiting for a supervisor. So when I realized the supervisor was not there, I contacted him by phone, at which time he said he was delayed. And when I came back up to the traffic stop, I did ask if you wanted to wait further for a sergeant, and I don't believe that you did, and then you drove off when you were free to go.
Yes. Is it correct that I was held on the road for approximately an hour waiting for this whole encounter to end?
I do not remember if it was an hour specifically, but I do remember that the time length was probably, I would say probably close to that at the very least.
Well, it was an hour, and it caused me to be late.
It does not seem reasonable to place the blame on the officer in this situation. The delay appears to have resulted from the individual's own choices, including insisting on a particular interpretation of their rights instead of following standard legal procedures. The officer also explained that additional time was taken because a supervisor was requested, which contributed to the situation. When all of this is considered together, it suggests that the outcome was largely shaped by those decisions rather than the actions of law enforcement.
Supervisor. That's all the questions I had.
Okay, any redirects?
No redirect, Your Honor.
Okay, any additional witnesses today?
None from the city.
Okay, Mr. L, are you calling any witnesses today, or did you want to give your own testimony?
I would like to, I have some, I have a defense, my motion.
Okay, well, you filed a motion?
Yeah, I filed a motion, served across the
When did
city
you file a
attorney.
motion?
It was filed, it was mailed February 18th.
You filed a motion and mailed it February 18th. Did you serve a copy?
To the clerk of the courts and also to the city attorney's office.
Did you receive any motion, sir?
Your Honor, we did receive a motion. It did not have any hearing date stated on it. We had no timetable for a response. I would be happy to respond to the motion on the record orally or provide the court with briefing if they would like.
The court didn't get a copy of the motion in February.
I sent it to the clerk. And,
Yeah, typically when that happens, it's just attached to the file. I don't have a copy of any motion.
Well, I did my due diligence. I sent a copy to him. He has his.
Well, I don't know that you did your due diligence, because when you file a motion, you got to get a hearing date for that motion. And so
who's supposed to give me a hearing?
you got to get the hearing date from the clerk's office.
From the clerk's office?
Yeah.
So why did they give me one?
Did you contact them for a hearing date?
I contacted them, yeah.
And asked for hearing dates for your motion?
And I asked when was my hearing. They confirmed that it was today.
For your motion.
And I asked, did I have a hearing date? And they said.
And you do have a hearing date, but that's not.
This situation shows how challenging it can be to represent yourself in court. Legal rules and procedures are more detailed than they may seem from television. In Michigan, Filing a motion also requires submitting a notice of hearing, which sets the date for the court to review the request. After all parties are properly informed, the court schedules a hearing where the motion is considered. Many courts are patient with individuals representing themselves and may still review an incorrectly filed motion, but this flexibility does not usually change the final outcome.
Gave him 21 days to respond.
Okay, you can make your motion before the court because I don't have a copy. You can make it now orally.
Okay. Well, now comes the beneficiary for Rambo L. Defendant in error, here by special appearance, not submitting to the court's jurisdiction, hereby moves the court to strike and dismiss the complaint filed by the officer Zenderbar. Am I pronouncing that right? Sorry if I'm not. For lack of ratification and commencement, no corpus delicti, no plaintiff lacks jurisdiction, personal jurisdiction. Christina Simmons being appointed as trustee, the prosecutors being appointed as co-trustee, I, Rambo L., an executor and beneficiary of a set of account. Also, I filed a declaration of non-citizenship nationality.
There seems to be a clear misunderstanding in this argument. Changing your name does not affect or cancel your citizenship in any way. In Michigan, a legal name change must be approved through the circuit court, which receives its authority from the state's judicial system. That same system also grants authority to district courts. So, if someone claims that a district court has no authority over them, it creates a contradiction, because the same legal structure was relied upon for the name change. This highlights an inconsistency in the overall reasoning.
The corporation in volume 20, corpus juris section 1785, we find United States government as a foreign corporations with respect to the states. Since the corporation is fictitious, is a fictitious person, it can't see, speak, smell, or touch itself. It's a fiction in the real world. It needs a conducting, transmitting utility, allegiance, some sort of connection to a fictional person. Constitutional Amendment number 1, Congress shall make no law respecting the establishment of a religion, prohibiting free exercise thereof, abridging freedom of speech or right of press or right of people, peaceful assemble, petition the government for redress of grievance. Number 5, Constitutional Amendment. The right of people should be secure in their person, houses, papers, and effect against unreasonable searches and seizures shall not be violated, and no warrant shall be issued upon probable cause supported by an oath or affirmation, particularly describing the place search of a person's things to be seized. And then number 7, Constitutional Amendment, suits at common law where value of controversy exceeding $20, the right of a jury trial shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States according to the rules of common law. I asked for a jury trial.
There's a misunderstanding in this claim. While Article 1, Section 14 of the Michigan Constitution does recognize the right to a jury trial in certain civil cases when properly requested, that right is not unlimited. Civil infractions are treated differently under Michigan law, and there is no specific statute or court rule that guarantees a jury trial for those matters. As a result, simply requesting a jury does not ensure one will be granted in such cases, since the procedure depends on the type of case involved.
I was not operating in commerce, nor was I a driver on the road for travel. A driver is an employee transporting goods or passengers. Rambo was just merely traveling in my private property. Here are some examples of my Supreme Court constitutional defenses. Number 1, case number 1, the right to travel is part of a liberty where a citizen cannot be deprived of due process under the Fifth Amendment, Kent versus Duels, 357 U.S.
In my previous video, I briefly mentioned Kent versus Doles, but it's important to clarify its relevance here. That case involved a passport denial and claims related to political discrimination, not issues involving driver's licenses or vehicle registration. Because of that, it does not apply to the current situation. The same applies to the other cases that will be referenced next, as they deal with different legal contexts. I will let the full list of cited cases be presented first, and then explain why each one does not support the argument being made.